Good afternoon, everyone. Welcome to the third annual C. Edwin Baker Lecture for Liberty, Equality, and Democracy at West Virginia University College of Law. I'm Joyce McConnell, the Dean of the College of Law. Ed, or Ed Baker, as he was known to his friends, was the Nicholas F. Galicchio Professor of Law and Communication at the University of Pennsylvania Law School. His connection to West Virginia University College of Law is through his friend and mentee, Professor Ann LaFaso. When Ed passed away unexpectedly, his sister decided to honor his legacy as one of the leading legal scholars of his generation with this lecture series. We are very, very proud and very honored that Nancy Baker chose West Virginia University College of Law to honor Ed's legacy. Professor Baker was an internationally recognized expert and scholar of constitutional law, communication law, and free speech. He was considered one of the foremost authorities on the First Amendment and on mass media policy. His most recent scholarship focused on the economics of the news business, political philosophy, and jurisprudential questions concerning the egalitarian and libertarian bases of constitutional theory. From his friends, I understand that Ed's mind ranged wide, that his thoughts were deep, and he loved nothing more than a good argument. Baker hailed from a small town, Madisonville, Kentucky, but found his way to Stanford, where he earned his bachelor's degree. He moved back across the country again and earned his law degree from Yale and served as a law and humanities fellow at Harvard University and a fellow at Harvard's Shorenstein-Barone Center. And he was also a Radcliffe Fellow. Professor Baker was a prolific scholar and correspondent. As one of the most important constitutional law scholars of the 20th century, we are privileged to be the home of the C. Edwin Baker Collection, representing each facet of this remarkable man's life. I now welcome to the podium Professor Ann LaFaso, Associate Dean for Faculty Research and Development, and very close friend of Professor Baker's, to introduce our speaker today.
Thank you very much, Joyce. Welcome, everyone. Ed was very important to me. I can probably name every teacher I ever had from kindergarten on. I didn't go to preschool. My teachers are always very important to me, and Ed was one of the most important people to me in my life. So it is very important to me that we've done this, and I'm very grateful to all of you who've decided to come and watch this, listen to this lecture. I have been personally involved in selecting the speaker each year, and I am very pleased with the person that we have selected today to talk about what Ed thought was so important, the First Amendment, and to honor his memory and his legacy in this very, very important area of law. Professor Heyman is a 1984 graduate of Harvard Law School, where he was a Supreme Court editor of the Harvard Law Review. After graduation, he served as a law clerk to Judge Harry T. Edwards of the United States Court of Appeals for the District of Columbia Circuit, and then as an associate at the Washington, D.C. law firm of Shea and Gardner. In 1989, he joined the faculty at Chicago-Kent, where he teaches torts, criminal law, legislation, constitutional law, and the First Amendment. And I should add that Chicago-Kent is one of the best law schools in the country for labor law, so I'm familiar with their faculty, and I'm very excited that we have a representative from that school here today. He's also been a visiting law professor at the University of Colorado, Vanderbilt, and Indiana University in Bloomington. And Colorado and Vanderbilt are also schools that Gordon Gee was president. I think we talked about that last night. So You're following him around. We appreciate that. Professor Heyman is a leading First Amendment scholar who has written extensively about freedom of speech and other aspects of constitutional law. In addition to many law review articles, he is the author of Free Speech and Human Dignity, which I believe that's the book we have in our bookstore that's on purchase, and also the editor of Hate Speech and the Constitution. The one on free speech and human dignity was published by the Yale University Press. Professor Heyman is a member of the Board of Advisors of the Chicago Lawyers Chapter of the American Constitution Society. Most importantly, Professor Heyman was born in West Virginia. Until he was 2 years old, he lived in Huntington, where his father was a professor of political science at Marshall. We won't hold that against him. The family moved to Washington, D.C., actually Rockville, Maryland, when his father was tapped to work for the Kennedy administration. By coincidence, our very own dean is also from Rockville, Maryland. I hope this is a happy homecoming for Professor Heyman. We are certainly thrilled that he has agreed to speak with us today. With that, please help me give a wild, wonderful, and warm West Virginia welcome to Professor Stephen Heyman.
Thank you so much. Thanks very much, Dean LaFossa, for that very generous introduction. I'm deeply grateful to the law school and to the Baker Center for asking me to speak here today. As the dean indicated, Professor Baker was one of the most brilliant constitutional scholars of his generation, and his work has had a profound influence on our understanding of freedom of speech and its relationship to individual self-realization and democratic culture. There can hardly be a greater honor for somebody who works in this field than to give a lecture in his memory. Liberty, equality, and democracy are central to our constitutional order, but the Constitution sets out those concepts only in outline and leaves a great deal of room for interpretation. So the history of American constitutionalism has been an ongoing struggle between competing understandings of the Constitution and the way in which it embodies those values. From the time of the New Deal through the 1960s, the Supreme Court often read the Constitution in a liberal or progressive manner. But since that time, most of the people who've been appointed to the court have been conservatives. And as a result, the court has gradually moved in a more conservative direction, adopted a more conservative view of the Constitution. It's important to recognize, though, that this view is not a monolithic one. In some cases, the justices have taken a traditional conservative position, that is to say, a position that emphasizes the authority of government to maintain law and order and to promote traditional social and moral values. So in accord with this view, the justices have reaffirmed the constitutionality of capital punishment, limited the right to privacy, and allowed more interaction between religion and the state. But conservative jurisprudence also has a second strand, which is what I'm going to call conservative libertarianism. This view holds that the Constitution should be interpreted to protect individual freedom and to limit the power and scope of the government. This view has led to recent decisions that expand constitutional protection for property rights, recognize an individual right to own firearms, and cut back on the welfare state and the regulatory authority of the federal government. Although these developments are well known, less attention has been paid to the way in which conservative justices have reshaped First Amendment jurisprudence. As I'll show, here too they've often taken a libertarian stance. Now, of course, Exhibit A here is the Citizens United case, in which a majority declared that business corporations have the same First Amendment rights as natural persons, including a right to spend unlimited sums to influence the outcome of elections. But I think you can also see the conservative libertarian trend in some other areas, such as decisions striking down restrictions on hate speech and pornography. In all of these cases, conservative judges have used the First Amendment as a barrier against regulation that sought to promote liberal or progressive values. It's tempting to attribute these decisions to the partisan inclinations of the justices. But I don't think that that's all that's going on here. Instead, I believe that these decisions reflect a broader political theory, which is founded on a distinctive view of individuals and their relationship to the state. This is the real basis for the conservative libertarian approach, which has become one of the most important strands in our First Amendment jurisprudence. So what I'd like to do this afternoon is to explore this approach to the First Amendment and to explain why I believe it to be flawed. I'm going to begin by sketching the basic theory that underlies the conservative libertarian approach. Second, I'll show how this approach applies to constitutional law in general. Third, I'll talk about how it's been used in the First Amendment area. Fourth, I want to talk about some of the problems that I see with the approach. And then finally, I want to outline an alternative theory of the First Amendment and to explore its implication for the cases that we'll be discussing. Let's start with the basic theory that underlies the conservative libertarian position. This theory is most fully developed in the works of political theorists like Friedrich Hayek and Robert Nozick, and constitutional theorists like Randy Barnett and Richard Epstein. The theory is not always articulated in the judicial opinions that I'm going to discuss, but I believe that it's often implicit in them and that it does a great deal to explain the results that they reach. So at the core of this theory is a conception of the individual. Following classical liberal theorists like John Locke, conservative libertarians see persons as free, equal, and independent. Individuals on this view should be free to do as they like, as long as they don't injure others. They have no inherent connections with other people, but only the ones that they voluntarily enter into. Following the philosopher G.W.F. Hegel, I'm going to call this view one of separate or exclusive individuality. That is, a view that sees individuals as sharply distinct from and often opposed to one another. On this view, society is essentially an aggregation of individuals who pursue their own self-interest through cooperation or competition in the market. As for the state, conservative libertarians often have a deeply ambivalent attitude towards it. So, on the one hand, individuals need the state in order to protect them from one another, as well as to defend the whole society against foreign aggression. But on the other hand, the state itself is seen as posing a serious danger to liberty. So this is where the Constitution comes in. On this view, the Constitution is designed to protect the negative liberty of the people against the government. The Constitution does this in two ways. One, by granting express protection to individual rights, and the other is by establishing a separation of powers and a division of authority between the federal government and the states. But of course, everything turns on how the Constitution is interpreted. Conservative libertarians think that if the Constitution is to protect liberty and to restrain the power of government, then it has to be viewed as a relatively fixed document, and interpretation has to be as objective as possible. It follows that judges must adhere to the original understanding, or at least be strongly constrained by history and tradition. Now that I've sketched the conservative libertarian view, let me talk about some of the constitutional decisions that flow from it. In many of these cases, the vote was 5-4, with the liberal justices in dissent. And I've tried to list some of the main cases in the handout that I gave you. So when I see myself as a separate and independent individual, then one of my deepest fears is that I'm going to be attacked by other people. So it makes sense that conservative libertarians would place a high value on the right to self-defense. That was the value at the heart of the Supreme Court's 2008 decision in District of Columbia against Heller. In that case, Justice Antonin Scalia ruled that the primary purpose of the Second Amendment is to protect an individual right to have firearms for self-defense and not to ensure the right of the states to have a well-regulated militia. Economic liberty and property are also central to the conservative libertarian view. Judicial protection of these rights reached its high point during the late 19th and early 20th centuries. During this period, which became known as the Lochner era, the court repeatedly used the Due Process Clause of the 14th Amendment and other provisions to strike down laws that regulated economic activity. And this led to a historic confrontation between the court and President Franklin Roosevelt, whose New Deal was threatened by these decisions. Under intense pressure, the justices backed down in 1937 and began to allow the government broad power to regulate the economy. In recent decades, a number of libertarian scholars and judges have strongly criticized the modern court's approach and have argued for a return to the jurisprudence of the Lochner era. Interestingly, this agenda has not made much headway in the Supreme Court, in part because originalist judges like Scalia and Clarence Thomas are skeptical about the notion that you can find any substantive protections in the Due Process Clause. But in a series of recent cases, the conservative justices have sought to protect economic rights by reinvigorating other provisions like the Takings Clause of the Fifth Amendment. Now, conservative libertarians believe that one of the greatest threats to freedom comes from the expansion of the federal government. In a series of cases, the majority has imposed some limits on the Commerce Clause, which is Congress's broadest source of power. The most recent case, as you know, is National Federation of Independent Business against Sebelius, in which 5 justices declared that Congress could not use the commerce power to compel individuals to buy health insurance under the Affordable Care Act. Conservative judges have also sought to rein in the modern state from another direction by rejecting the view that the Constitution gives individuals affirmative rights to public goods or services. One of the leading cases here is DeShaney against Winnebago County, in which the court ruled that states don't even have a duty to protect their citizens against private violence. In the words of Judge Richard Posner of the Seventh Circuit, decisions like this stand for the proposition that the Constitution is a charter of negative rather than positive liberties. Finally, you can see the conservative libertarian view at work in the area of equal protection. So, for example, in cases like Gratz against Bollinger and Parents Involved against Seattle, the conservative justices have used a formal conception of equality or colorblindness to limit the government's ability to use race-conscious measures to combat inequality. Now let's talk about how the conservative libertarian view plays out in the First Amendment area. So one of the path-breaking cases here is called American Booksellers Association against Hudnut, which was decided by the Federal Court of Appeals for the Seventh Circuit in 1985. The case involved a feminist anti-pornography ordinance that was drafted by Catherine McKinnon and Andrea Dworkin, and that was later adopted by the Indianapolis City Council. In Hudnut, the court struck down this law in an opinion by Judge Frank Easterbrook. Remarkably, Easterbrook begins by conceding that pornography causes all of the serious harms that McKinnon and Dworkin say that it does, from sexual violence and employment discrimination to social and political subordination. But Easterbrook contends that the very purpose of the First Amendment is to protect the power of speech to shape people's thoughts and actions, no matter how much harm that might cause. According to Easterbrook, if we allow the government to adopt laws to influence the way that people are socialized, that would, quote, leave the government in control of all the institutions of culture, the great censor and director of which thoughts are good for us. For this reason, he insisted that under the First Amendment, the law has to remain neutral in the cultural struggle between those who see women as equal citizens and those who see them as mere sexual objects to be possessed or dominated. Because the ordinance took sides in the struggle, Easterbrook held that it violated one of the most basic principles of First Amendment law, which is the rule that the government may not discriminate against speech because of the viewpoint that it expresses. In 1992, Justice Scalia used similar reasoning in a case called RAV against City of St. Paul, which involved an ordinance that banned cross-burning and other forms of hate speech. As interpreted by the state courts, the ordinance didn't prohibit all hate speech, but only that which amounted to fighting words, which is a category that the Supreme Court has never said is protected by the First Amendment. So when the ordinance was construed in this way, then it clearly seemed to be constitutional. But when the case went up to the Supreme Court, Justice Scalia held that while a city may ban all fighting words, it is not allowed to ban only those based on race, because that raises the possibility that the city is really striking at the racist ideas that are being expressed. On these grounds, the court ruled that the First Amendment doesn't allow the government to adopt even very narrow laws targeted at hate speech. We now come to the Citizens United case, which was decided 4 years ago. Several earlier cases had held that the government could prevent corporations from using, quote, resources amassed in the economic marketplace to obtain an unfair advantage in the political marketplace. In Citizens United, Justice Anthony Kennedy and his conservative colleagues overruled these cases and instead held that corporations have the same First Amendment rights that individuals do, and that they may spend as much money as they want to influence elections. You may have seen that just yesterday the Supreme Court decided a follow-up to Citizens United. The case is called McCutcheon against FEC. I'm afraid it's not in your handout. I told Dean LaFazzo that as soon as I sent her the handout, the Supreme Court was sure to decide some major First Amendment case. And so, sure enough, I was right about that. In McCutcheon, the same 5-4 majority as in Citizens United struck down a limit on the amount that wealthy donors can contribute to political parties and candidates across the country. The dissenters warned that this decision would open the floodgates for money in politics even wider than they already are. But in his plurality opinion, Chief Justice John Roberts maintained that the First Amendment gives individuals a right to participate in the political process by making contributions, and that this right can't be restricted simply because Congress or even the public as a whole believes that this is going to harm our democracy or drown out the voices of other citizens. The final case that I want to mention right now is Boy Scouts of America against Dale. In that case, Chief Justice William Rehnquist held that the state of New Jersey violated the freedom of association when it told the Scouts that they couldn't exclude individuals based on their sexual orientation. So if you take these 5 cases that I've just mentioned, Hudnut, RAV, Citizens United, McCutcheon, and Dale, then I think you can see some of the main features of the conservative libertarian approach to the First Amendment. So to begin with, these decisions understand the positive functions of speech in line with the general theory that I sketched earlier. Free speech is seen as a right that allows separate and independent individuals to pursue their own private interests and desires, as in Hudnut, or their moral and religious values, as in Dale. The conservative justices also see free speech as vital to democratic self-government. But I think if you look closely, you can see that their position differs from the classical view that was articulated by Justice Louis Brandeis and by the philosopher Alexander Meiklejohn. Brandeis and Meiklejohn saw political speech as a way for citizens to deliberate with one another about the common good. By contrast, the conservative justices regard public debate as a marketplace in which individuals and groups use their resources to promote their own private interests and beliefs. These 5 decisions also reflect conservative libertarian theory in a second way. For the most part, they see free speech as a form of negative liberty. So in Hudnut and RAV, for example, the conservatives don't claim that pornography or hate speech have any positive value. Instead, they stress the dangers of government censorship. A third and final point is this. For conservative libertarians, the danger to freedom comes not only from the government, but from the society as a whole. In Hudnut and RAV and Dale, the majority uses the First Amendment to protect individuals against the imposition of social norms, like equality, dignity, and respect for others. The conservative judges treat the enforcement of these norms as instances of political correctness or thought control. It's no accident, then, that some of the leading cases involve expressions such as racist hate speech or misogynistic pornography. For conservative libertarians, one of the crucial functions of the First Amendment is to protect speech that's antisocial in nature. So let me now turn to a critique of the conservative libertarian approach to the First Amendment. And I want to highlight 4 problems with this view. First, I believe that decisions like Citizens United and McCutcheon draw too close a connection between free speech and property rights. Libertarian theorists like Professor Epstein argue that the court's approach is consistent with Lockean natural rights theory, which strongly influenced the Constitution. But I think that if you read Locke carefully, you see that he drew a basic distinction between inalienable rights, like freedom of speech and thought and belief, which were beyond the power of the state altogether, and contrasted those with rights like economic liberty and property, which were subject to regulation for the common good. Locke also warned strongly against the danger that private interests would come to dominate public decision-making. So it seems to me that when it comes to speech and property rights, the conservative libertarian approach turns out to be unpersuasive even in its own terms. The second problem with the approach is that it gives too much protection to speech that abuses or degrades other people. As I've said, conservative libertarianism sees people as separate individuals who have no inherent connection with one another. When viewed in this way, the individual is a subject who tends to see himself as the center of the world. And although he may choose to cooperate with some people, he may regard others as mere objects to be used for his own purposes, as with the violent and degrading pornography in Hudnut. or as enemies to be dominated or destroyed, as with the hate speech in RAV. Now, I want to be clear about this. I'm not suggesting that conservative libertarians approve of such expression. They don't. But they do hold that it has to be protected in order to guard the selfhood of the speaker against the imposition of social norms. And I would argue that this position is actually self-defeating, because abusive and degrading speech not only injures the personality of the targets, it also injures the speaker's own personality by undermining his humanity and his relationship with other people. The third issue that I want to raise is whether the conservative libertarian approach is internally coherent. As the name that I've given it suggests, this approach represents a kind of fusion between libertarianism on one hand and traditional or social conservatism on the other. These two strands of conservative thought are united in their opposition to what they regard as liberal legal orthodoxy, but there's also a deep tension between them, because they seem to be rooted in very different views of the social world. Libertarians see society as an association of individuals whose freedom has to be paramount, while social conservatives view society as a larger whole, which should promote not only the freedom of individuals, but also their moral well-being and the good of the community as a whole. The tension between these two positions isn't apparent in the First Amendment cases that I've been talking about, when regulation comes from the left, right? Because those regulations can be imposed both on traditional conservative and also on libertarian grounds. But the conflict between these two strands comes out clearly in some other situations, involving, for example, violent video games or depictions of cruelty to animals, where regulation comes from somewhere else on the political spectrum. In cases like this, some justices, like Kennedy, take a libertarian position, while others, like Samuel Alito, take a social conservative one. The underlying problem, I think, is that in the end, the conservative justices regard both individuality and community as important values, but they have no clear way to resolve conflicts between these values. The fourth and final problem that I want to mention has to do with neutrality. As we've seen, the conservative judges insist that when the state regulates speech, it has to adhere to a rigorous ideological neutrality. And they often use this principle to strike down regulation from the left. But from what I've said, it ought to be clear that the conservative libertarian view fails to live up to its own standards of neutrality. Hudnut is a perfect example. In that case, Judge Easterbrook ruled that the state could restrict sexual material on the ground that it violated traditional standards of decency, but not on the ground that it undermined the equality of women. Likewise, in United States against Stevens, from about 3 years ago, Chief Justice Roberts declared that the only categories of unprotected speech are those that historically have been unprotected. It seems to me that this position is tailor-made for striking down progressive regulations of speech while upholding regulations that promote traditional values. Now, to be clear, I don't mean to say that the problem with the conservative libertarian view is that it lacks ideological neutrality. In my view, and I think this was Ed Baker's as well, while a free speech theory should protect as broad a range of views as possible, any such theory ultimately will be based on a substantive conception of the individual, the society, and the state. It follows that our goal should be to develop a view that is sound rather than a view that's neutral. The objection that I'm raising then is not that the conservative libertarian view embodies a particular position, but that it condemns other views for this, while turning a blind eye to its own ideological character. So how should we think about freedom of expression? In the time remaining, I want to sketch a different approach, which I call a liberal humanist theory of the First Amendment. Although I'm not wedded to this label, and if anybody has a better suggestion, I'd be happy to consider it. I call it liberal humanist, liberal in the sense that it places a high value on individual freedom, humanist in the sense that it seeks to promote the fullest realization of human nature and the human good. The problems with the conservative libertarian view, I think, can be traced to its theory of the self. This theory holds that we're all separate and independent individuals that have no inherent connections with one another. Now, of course, we are separate individuals, but we're also social beings. We find our identity and our fulfillment not only through the development of our individuality, but also through our social relationships and our participation in community. On this view, the ideal should not be separate or exclusive individuality, but what you might call individuality in community. freedom of speech should be understood in this context. Speech is not only subjective, it's also intersubjective and social. And what I mean by that is when I engage in discussion, as we're doing here, for example, I'm not merely expressing my own thoughts and feelings, I'm also communicating with other people and forming a relationship with them. This relationship may be based on many different things, such as a common interest in March Madness or politics, or in trying to understand the rule against perpetuities. But at bottom, the relationships that are formed through communication are always based on mutual recognition. Individuals can communicate with one another only if they regard one another as intelligent beings or persons. For this reason, I would argue that the right to free speech carries with it a duty to recognize the personhood of others, as well as the rights that flow from that status. It follows that free speech doesn't give you a blank check to invade the rights of other people. Speech that infringes these rights without adequate justification is wrongful and shouldn't receive constitutional protection. As I've shown elsewhere, this is a principle that was widely accepted at the time that the First and the 14th Amendments were adopted. But how can we tell what these rights are? Right? This notion that there are other rights that might limit free speech. On the view that I'm taking, rights are rooted in respect for human freedom and dignity. We can determine what rights people have by exploring what it means to be a free person in different spheres of human life, including the external world, the inner realm of thought and feeling, the social and political domain, and the sphere of intellect and spirit. The right to free speech can be understood on all of these levels, as I'm going to show in just a moment. But in each case, the principles that support free speech also support other fundamental rights that deserve protection under the law. So in this way, I think we can determine when speech should be protected under the First Amendment and when it shouldn't be. I've tried to capture this view on the reverse side of your handout, which situates free speech within a broader framework of rights. If you'll allow me, I want to spend a minute or two looking at parts of this table. To start with the first row, one way to see free speech is as a form of external freedom, right, or the right to control your own mind and body without interference by others. To a large extent, I think this is how conservative libertarians understand freedom of speech. At the same time, other individuals also have a right to external freedom, including a right to personal security or freedom from violence. Likewise, the community has a right to the public peace. Speech violates these rights when it constitutes an assault, a threat of violence, fighting words, or incitement. A second rationale for free speech is one that was central to Professor Baker's theory of the First Amendment. That rationale holds that free speech is essential for individual self-realization. But it seems to me that, that there are other rights also, like emotional well-being, privacy, personal dignity, and reputation, that are also vital for self-realization. For this reason, I would argue that the law should be able to impose some restraints on intentional infliction of emotional distress, invasion of privacy, insulting words, and defamation. A third justification for free speech is the one that we glanced at a few moments ago. It's the one associated with Justice Brandeis and Professor Meiklejohn. On this view, the First Amendment protects the ability of citizens to engage in democratic self-government. But of course, other people also have rights of citizenship and participation, which may be harmed by certain kinds of speech. And the community as a whole has a right to democratic self-government. There's a lot more that could be said about the handout, but this should give you a sense of the liberal humanist approach. This approach takes the different theories of free speech that we've touched on this afternoon. So the conservative libertarian focus on individual freedom, Professor Baker's ideal of individual self-realization, and the democratic self-government view of Brandeis and Meiklejohn, and it seeks to integrate them into a broader and more comprehensive theory of the First Amendment. And at the same time, this approach suggests ways to allow us to harmonize the principle of free expression with social values such as dignity, equality, and community. So let me give you an illustration. Consider the problem of funeral picketing. So as most of you know, in recent years, a group called the Westboro Baptist Church has picketed tens of thousands of funerals across the country, holding signs emblazoned with homophobic slurs or with slogans like, "Thank God for dead soldiers," "Thank God for IEDs." you're going to hell, God hates America. In a case called Snyder against Phelps, the Supreme Court acknowledged that this picketing causes great pain to the mourners, but ruled that the picketing is political speech that's entitled to First Amendment protection. This opinion, which was written by Chief Justice Roberts, I would say is consistent with the conservative libertarian view. I think this case will look very different from a liberal humanist perspective. Westborough's speech is meant to target the people attending the funeral. By intentionally interfering with their ability to mourn their loved ones, the speech invades their right to privacy, dignity, and emotional well-being, as well as their religious or spiritual freedom. On the other side of the balance, the picketing does express Westborough's religious beliefs and its attitude towards America, but it seems to me that nobody should have a right to force such views on the mourners at a funeral. And if the church members, if what they want to do is to communicate with the public at large, they have many ways to do this that don't cause such serious harm to the mourners. So for these reasons, I believe that reasonable restrictions on funeral picketing should be upheld under the First Amendment. The liberal humanist approach would also lead to different results in the other First Amendment cases that we've discussed. So in Citizens United and McCutcheon, the majority held that the government has no power to restrict electoral speech by corporations or huge contributions by wealthy donors. In my view, however, the First Amendment doesn't compel us to treat public debate as a marketplace in which speakers are free to use their economic resources without restraint to promote their private interests, and in which the most powerful interests do and should prevail. Right? That's the marketplace view. Instead, if the American people believe that unlimited corporate spending or very large political donations would interfere with their capacity to engage in self-government, then I think they should be allowed to use the democratic process to restrict these activities. In this regard, I'm on the same page with Professor Baker. Throughout his career, Baker was a strong critic of all theories or doctrines that put property rights on a par with free speech or that would allow corporations to influence elections. I also think that Justice Scalia's decision in RAV was misguided. The court was right to reaffirm the traditional view that the First Amendment doesn't protect fighting words, but the majority was wrong to hold that the law may not impose greater restrictions on fighting words that express group hatred. On the liberal humanist view, fighting words are unprotected in the first place because they violate the target's rights to personal security and dignity, as well as the community's right to keep the peace. But when one person hurls racial insults at another or burns a cross on her lawn, he not only threatens her personal security and dignity, he also violates the most basic right that people have, which is the right to be recognized and treated as a human being and a member of the community. It follows that there was nothing unprincipled about the St. Paul Ordinance. The city could reasonably believe that some forms of fighting words are more deeply wrongful than others and that they merit a stronger response. In Hudnut, the Court of Appeals reviewed an ordinance that restricted some forms of pornography, especially those that involve graphic sexual violence. And as we saw, Judge Easterbrook conceded that material of this sort subordinates women, leads to violence and discrimination against them. But he insisted that the First Amendment protects speech precisely because of the impact that it has, whether that impact is good or bad. This position is diametrically opposed to the one that I put forward, which holds that free speech can be regulated to protect the rights of others. People have a right to be free from violence, discrimination, and other forms of subordination that are incompatible with their status as free and equal citizens. If Easterbrook is correct that violent pornography has such an impact on individuals in the community, then that material should not be entitled to First Amendment protection. Now, of course, whether violent pornography does have this impact is a deeply contested issue, and this isn't the place to try to resolve it. But it seems to me that from a liberal humanist perspective, three things are clear. First, contrary to Easterbrook's position, the freedom of speech should not be understood as a broad privilege to inflict harm on other people. Second, in a modern liberal society, the prevention of such harm is a more persuasive rationale for regulation than is the promotion of public morality, which is a rationale that the conservative judges accept. And third, when the state adopts otherwise permissible laws to prevent harm to others, it doesn't violate the rule against viewpoint discrimination, but simply fulfills its duty to protect its citizens against injury. In the Dale case, the majority held that the Boy Scouts had a First Amendment right to exclude gay people from membership. This decision, I think, is consistent with what I've called the idea of separate or exclusive individuality. Just as private property has traditionally been understood in terms of the right to exclude others, so Dale understands freedom of association in the same way, as a strong right not to associate with people whom one dislikes or disapproves of. By contrast, liberal humanism holds a more inclusive view of the self. It sees free association as an expression of our natural inclination to form social relationships with others. Moreover, what an association does is capable of affecting not only its own members, but also other individuals and the community as a whole. It follows that the right to free association, like the right to free speech, is not absolute, but has to be harmonized with other norms, such as the right to equality and the right to recognition as a person and a member of the community. Associations certainly should be free to limit their membership to people who share their purposes and values, but they shouldn't necessarily be allowed to engage in invidious discrimination. If the Boy Scouts had refused admission to racial minorities, it seems likely that the case would have come out the other way, and I would argue that we should reach the same result when the discrimination is based on sexual orientation. In conclusion, one of Professor Baker's strongest convictions was that the First Amendment should be understood in light of our conception of the individual and our understanding of human liberty. I've argued this afternoon that the conservative libertarian approach is based on an overly narrow and one-sided view of the self. Although we are separate individuals, we're also social beings who share a common life. To be convincing, an account of liberty must recognize both sides of our nature. It must affirm not only the value of individual autonomy, but also the social dimension of liberty, the freedom that we find through relationship with others. From this perspective, I believe that it's a mistake to see a fundamental conflict between individual liberty and social values, and to hold that a central purpose of the First Amendment is to protect expression that violates social norms. Instead, First Amendment jurisprudence should seek to reconcile the right to free speech with other basic rights such as personal security, privacy, reputation, citizenship, and equality. In my view, this is the best way to promote the values of human freedom and dignity on which our Constitution is based. Thanks very much. I'm eager to hear your thoughts.
I know that Professor Heyman is welcome to take questions, and if you do have a question, if you'll go to the microphone, that way we'll make sure that everyone who wants a recording of this will be able to hear the full dialogue.
Hi, my name is Mark Moses. I'm a 3L.
Hi, Mark.
Hi. We were actually at the decision yesterday, so several of us got the opportunity to hear McCutcheon actually be read, which was really, really cool experience.
So both the Chief Justice's holding and Justice Breyer's dissent.
Right. It was almost like an informal debate right there in front of us, so it was cool. But afterward, I was discussing a point that I think that you made, and I'd like to hear a little bit more about it. Are you trying to distinguish between free speech and property rights in the sense that political spending shouldn't be counted as free speech? Is that, and if so, how would we fix that? Because I agree with the dissent, and I would have hoped it would have gone the other way. But
yeah, it's a very interesting question. I think what we want to distinguish is freedom of speech itself, and then the means to engage in freedom of speech. So I wouldn't say that the government could ban sort of all spending or all donations of money in order to promote your political views, because sort of very traditional sort of accepted principle of interpretation that if the law gives you a right, then it also gives you the means to exercise that right. So if you have a right to engage in free speech, then you also have a right to use your resources to engage in free speech. But what I think is, so I don't want to take the extreme position that money simply has nothing to do with free speech or with the political process. What I would say, though, is that I think the majority takes a sort of a blinkered view of the nature of the political process when it sees basically an unrestrained right to use all of your property for purposes of expression. Because it's viewing viewing the nature of the political process in an excessively individualistic and kind of private way, without looking at the effects on speech as a whole, on public debate as a whole. I think that was really the essence of the disagreement between the majority yesterday and Justice Breyer in dissent. The majority says First Amendment protects the right of individuals to engage in expression, and so anything that restricts that is subject to sort of very sharp scrutiny and is likely to be struck down. Justice Breyer said that of course individuals have a right to participate in political debate, but that also this is something that sort of applies to the community as a whole, that in order to have a functioning democratic process, it's necessary to combat a situation where some people can use such overwhelming amounts of money that they drown out the voices of others or that they come to dominate the process. And he said it's perfectly reasonable for the legislature to reach a conclusion that certain kinds of limits need to be imposed. That's basically how I would see it.
Okay, thank you.
Hi, I'm John Taylor. I'm on the faculty here. Thank you for coming. I enjoyed your talk.
Thank you.
I haven't looked at it in a while, but as I recall, Alito dissented in Snyder versus Phelps, right?
He did.
And I take it from what you said that you would say this is an instance where he kind of embraced the conservative side of the conservative libertarian split in upholding this. You suggest, in dissenting from the majority's ruling in Snyder v. Phelps, and I gather you actually agree with him on the result, that the case would have come out differently for you. It might be helpful if you could sort of review for people how Alito gets there using this kind of conservative jurisprudence that you described versus how you would have gotten the same result if you'd been writing it from a sort of liberal humanist perspective.
Yeah, thank you. Very, very interesting question. I sent Justice Alito my book after it was published.
There you go.
He sent me a very nice acknowledgement, but I don't seem to have persuaded him exactly. So Snyder against Phelps is the case that I mentioned involving funeral picketing. Right? It involved a 20-year-old Marine who died in Iraq. So his family was going to hold a funeral for him in Westminster, Maryland. And what happens is that when the local newspaper or some local online source posts a notice about a funeral coming up, the people at Westboro in Topeka, Kansas, sort of find this information, and they issue a press release announcing that they're going to go and descend on the funeral, and that they're going to picket, and that's what they did in this situation. So they issued this big release that talked about how Matt Snyder was in hell, and how they were going to picket, I think, what they called the whorehouse called St. John's Catholic Church, and bring their message to the people there. And they did arrive there, and they held up the kind of signs that I was talking about. So the Marine's father, Al Snyder, brought a lawsuit against Westboro for intentional infliction of emotional distress and invasion of privacy. And he actually won at the trial court level. He won a $5 million judgment against Westboro. And the case was then appealed. And when it got to the Supreme Court, then the court ruled 8-1 to overturn the damages award. Chief Justice Roberts' majority opinion is it's a little schizophrenic, right, in the sense that on the one hand it insists that he's writing a very, very narrow opinion that's just limited to the facts. And the facts in this case involved the fact that Westboro, because they sort of misunderstood exactly where the funeral was going to be, asked to set up at a point that was about 1,000 feet away from the funeral, and the police said, okay, fine. And as a result of that, the mourners at the funeral were not directly exposed to the signs and the chanting and so forth. They found out about it later when they were watching the news or when they picked up the newspaper the next day. So in that sense, the facts were not very strong for the plaintiffs. And so on one level, the opinion that the Chief Justice writes says just looking at these particular facts, there was no kind of direct communication of these views to the mourners. Instead, they were basically communicating with the public. That's political speech. It's protected by the First Amendment. But on another level, the Chief Justice talks about how free speech hurts, like beauty hurts, and that we protect free speech even though it can cause great pain to somebody in this situation here of the mourners, because we have this overriding commitment to freedom of public debate. So Justice Alito was the sole dissenter in the case, and the opinion that he wrote said, look, I think this wasn't really public speech. This really was private speech that was directed at these mourners. And he says, given that, it should not be entitled to sort of extraordinary First Amendment protection. Instead, it simply should be treated in the way that we treat a lot of ordinary private speech. And he says this speech was a vicious verbal attack on the Snyder family, that it was intentionally meant to cause as much pain and harm as it could. He says that I think our basic values do not require us to protect speech of that sort. I do agree with the result that he reached there, and I agree with much of what he says in the opinion. But I guess one way in which I would differ with him is that I don't think that we need to draw this very sharp distinction between public speech that's almost always protected and then private speech that is subject to much greater regulation. In this situation, I think Westboro they were doing both, right? I mean, they were engaged in public speech. It was also, though, targeted specifically at these mourners. And so what I want to say is that free speech is a fundamental right, but it's limited by the rights of other people. And even if it takes place in the public sphere, still, it has to respect the basic rights of other people. So in a situation where you engage in public speech that defames somebody, there are conditions under which you can be held liable. If you engage in public speech that in effect conveys a threat of violence against, say, abortion providers, then the courts have said that you can be held responsible. I would say the same thing here, that simply because the speech had a public dimension shouldn't insulate it. We still need to identify what the competing rights are, and then engage in a very sort of careful and thoughtful assessment of question one, whether the speech violates the rights of the mourners to privacy and emotional well-being, and then secondly, whether the speech is so valuable that it ought to be protected despite that injury that it causes. And for the reasons that I said, I don't think that's the case here.
Cool. Thanks. I teach at one, so don't take my running out as a bad sign. Thanks a lot.
Professor Taylor told me he was going to have to run out early, so he is telling the truth right now and not trying to target you or hurt you in any way. Thank you so much. That was a wonderful, wonderful talk. One thing I'm getting out of your talk is this idea that there are many rights that we have in society and that they can come into conflict, and we need a way of then figuring out how to resolve those conflicts. So do you have a hierarchy of rights, or how do you resolve those? Because I know when I was in law school, the big conflict that everyone wanted to talk about was between the First Amendment free speech and equality, especially like pornography, things like that. But how do you decide to do that? And if it's ad hoc, there must still be, in order for this to have any kind of predictability or stability in our society, there has to be some way that we can at least figure out how to resolve them, even if it's done on a case-by-case basis. So how would you do that?
Yeah, it's a very good question. The first thing I want to do is to sort of set out a framework of rights in the way that I tried to do on the back of the handout, and to try to show that free speech is, we shouldn't understand it as being this sort of unique right. we should see it as part of a larger set of rights that people have. And so that's one way to develop the account of what rights there are, because you can then say free speech is a form of external freedom, but then people have a right to freedom from violence. Free speech, as Baker thought, is sort of a right of personality. It's a right of self-expression, self-realization. But then there are other rights like privacy or reputation that are like that also. So that's part of it. But when you have to resolve conflicts between different rights, let me say I think it would be too artificial to have a sort of a very clear-cut hierarchy. Free speech is, of course, one of the very most fundamental rights that we have. But so that would lead you to say, well, free speech almost always ought to be protected. But if you have a conflict between free speech and somebody's personal safety, I would say your personal safety is also one of the very most fundamental rights that we have. And so for that reason, I think I would find it hard to set out some very clear hierarchy. What I would say, though, is that all of these, you do have to have a common denominator. Otherwise, you're just comparing apples and oranges. And then you have exactly the concern that you've raised, which is that any decision between free speech and, let's say, privacy would be arbitrary, would be ad hoc. You can't predict it. It might simply reflect the subjective views of the people that are making the decision. So I think you do have to have a common denominator. And I would say that the common denominator is that all of these rights are rooted in respect for human dignity and autonomy. And so in any given case, I think what you want to do is to ask, would we better promote human freedom and dignity by protecting free speech in this instance? Or would we better protect it by protecting the opposing rights? And that sounds pretty abstract, but I think that in many situations, there'd be a lot of intuitive agreement on how we should come out. So, I mean, that's my view about funeral picketing. I think that if you convince people that they're not betraying free speech, if they're willing to entertain the possibility of limiting it in a situation like that. And so if you get people to ask the question about how the balance between free speech and privacy and emotional well-being should come out in the funeral picketing case, I think a very large number of people would say that they don't have a right to sort of ruin the day on which these people are mourning the loss of their loved one by showing up at the funeral with these kinds of signs directly targeted at the mourners. I might be wrong about that. Maybe there'd be much more.
I find that very persuasive, and I too, in my work, go to autonomy and dignity as the two most fundamental values. But one thing I'm struggling with, and I'm just wondering as a follow-up question, is sometimes autonomy and dignity themselves can be in conflict. And while I don't find this a persuasive example, I know a lot of people do. I'll give you the following, is that what about a woman who's a sex worker who feels it's her autonomy to engage in the sexual act for money, but others might find it degrading and it's a loss of her dignity? We're obviously not going to resolve that, but there's many examples of this, and so it's something I personally struggle with, although I do think I am in agreement with you that those are the two most fundamental values we can try to express in the law and in our society.
I think that's as much common ground as we can hope for. That is, I think that sort of the key thing that I'm trying to do is get us to ask the right questions. And I think that sometimes when we ask the right question, which I would say the question is, should we protect the right to free speech as opposed to these other rights in a situation where they come into conflict? And by asking the question, which resolution of the conflict would best promote human freedom and dignity? If we pose that question, I think that there are some cases that are fairly easy, some cases that are moderately easy, some cases that are very hard, and that would involve sort of a lot of debate. And I think that sometimes this debate, is influenced by people's ideological, views. And I don't think that there's any way to eliminate that in the law. which is one reason why I say that our goal should not be to get some kind of pure neutrality, but instead to recognize the disagreements that people have. So I wouldn't claim that the approach that I'm taking here is capable of resolving all issues or leading to some kind of mechanical answer. I think there are some legitimately hard conflicts of rights. But I think that we would get much further if we posed the question that way and then had a substantive debate about the best way to promote those values, rather than to dodge the issue with various things like this rule against content discrimination or other sort of more formal doctrines that are meant to allow judges to escape the need to make those judgments. And then in the end, I mean, if we do that, then I think we have to rely on not just the legal knowledge, but the sort of wisdom and thoughtfulness of judges, as well as a broader debate within the society about how to resolve those issues.
Thank you very much.
Hi, my name is Nick Parker. I'm a 2L here. Very much enjoyed your lecture. Thank you for coming here.
Thank you.
I was just wondering, you're talking about balancing your rights versus like for autonomy and dignity, and specifically on here that you're talking about like insulting words and hate speech, things that a lot of people find offensive, of course. I was just wondering if you could further clarify like where you would draw the line between criticism and insults and hate speech, and how that would relate to the chilling effect that you might create by limiting these forms of speech.
Thank you. Great question. This is clearly going to be one of the key things that you'd have to deal with a view like the one that I'm expressing. So to begin with, I mean, as a matter of principle, I think that we have to have there's a very high value on the ability to criticize other people's views. I mean, there should be full and free debate about creationism, about evolutionism, about various ideological, political, religious viewpoints that people have. Nobody has a right to be free from reasoned discussion about these views, and that discussion sometimes can get heated. It is not always conducted in sort of dulcet, civil kinds of tone. I think we also have to have a right to be able to assess one another's conduct and character, and to make judgments about that. I mean, that's at one end of the spectrum. On the other end of the spectrum, I don't think that we can engage in any of those kinds of activities that we were just talking about. So, reasoned discussion about people's views or their character, except on the basis of what I'm calling mutual recognition of everybody's status as a person and a member of the community. So that's where I think the critical line is. I think when you get to the point where somebody is not just engaged in, sort of impassioned debate about some issue of public concern, but is actually denying the humanity of the people that they're targeting. I think that's the key place where you cross the line. Cross burning, is a good example of that. I think the cross, as the Supreme Court has come to recognize, burning a cross represents a, very well understood, traditional way of saying, you don't belong here. We don't recognize you as a person, as an equal member of the community, and with a sort of implicit threat maybe behind it, that if you don't leave, then we're going to take more violent measures. Justice Scalia in RAV insists that cross-burning is just another kind of speech. He thinks it's a bad kind of speech, and he's perfectly willing to allow a city to ban it if they have some broader ban on fighting words or on threats. But he insists that if you were to impose some kind of greater penalty on cross-burning, that you would be singling out a particular kind of expression, which is something the First Amendment is meant to be protecting, and I guess I didn't see that. One place I would draw the line is between speech that denies the humanity of others and speech that doesn't. And another place, to take the example of criticizing somebody's conduct, would be to look at the way that the law traditionally has dealt with issues like defamation. They may need to be adjusted, as the court has, in order to give adequate protection to expressive interests. But in ordinary law, we're always having to decide how to draw the line and how to decide what conduct is unlawful and what conduct is protected. We have to do it in every area. When you're defining what's an assault, what's a battery, what is a sexual assault, what the different degrees of homicide are, when you have a right to self-defense, and when, or to stand your ground, right, and when when that's unlawful. Those are always issues of line drawing that we have to engage in. I guess part of what I want to say is that the First Amendment doesn't really allow us to escape from that kind of very thoughtful, careful line drawing consideration. So we do it with defamation, we do it with fighting words and threats and so forth. And I think that there are other areas too where it's appropriate to do it.
Thanks.
Thank you very much, Professor Heyman. Thank you for taking so many questions. We appreciate it. Thank you all for being here this afternoon for this excellent presentation. Thank you.